So, very good morning, everybody. I think we're the odd ones out. We're looking at one of the other players. Who's STP? We're looking at one of the actors in that sort of money-making machinery of supply chains that has received very little attention in the past, but it's sort of coming to the picture now. The certification organizations. Here, in this case, this is what was Ali Enterprises before it burned down, or in the process of burning down, actually. This was Kik, who was the buyer, and they had a contract with a certification organization from Italy called Rina that had certified fire safety of that building just 3 weeks before it burned down. Well, obviously, not quite accurately so. Other actors in that field are, for example, TÜV Rheinland, one of the world leading certification organizations, or Bureau Veritas, that has already popped up in case law. Now, what we want to do is a kind of a doctrinal exercise, sorry for that, based on contract and tort. And we will take a step-by-step approach, so we'll not go straight to this picture, but we will start from safe ground and then move on to the ever more slippery one and see at one point we slide. Now.
Yeah. Okay, so this will be the very last and most slippery approach, but it will be a long journey to get there, and I would really like to start with the public role of certification organizations, which, just from the starting point again, the state duty, I have to do it. The state duty to protect, the classical triangle, so the state duty to protect also against damages caused by economic actors to third parties, which then in a next step or in certain areas has been privatized to private certification organization by the German concept of entrusting a certification organization with a public office, with public power. The idea behind that, of course, is to unburden the state from the task of controlling. And the state duty to protect then changes into a responsibility to ensure protection, which is done by an accreditation of the certification organization, the control of the certification organization, and high thresholds concerning the expertise, the independency, the professional integrity of the certification organization. But the triangle in that picture is still intact. So it is still accompanied by state liability in case the control task has not been carried out properly. So the idea is to refer to the German Supreme Court already in 1967. So it is not relevant that it is a private actor that controls, but what is relevant is the public duty that is being carried out, which is defined by law as part of a legal safety structure. Basically, so these are the relevant requirements.
Just a comparative remark to what we believe is English law. That works in the same way for England. There's a case called Peretz and Collins, which was about the safety certification of an aircraft that fell from the sky. And the only difference here is the English court found a duty of care of that safety inspector, but that was not attributed to the state, so he himself was liable, had to pay. But under the regime of the Civil Aviation Act, the safety inspector would then be indemnified by the state. So after all, it's a similar structure, just not exactly the same. Now we move this one stage up to the European stage, where we are still on pretty safe ground because we had a spectacular case, the case of the breast implants, the PIP case, polyimplant prothèse, which for those who don't know, was a big scandal. PIP was producing breast implants, and rather than using medical silicone as they promised to, they used industrial silicone, which is much cheaper, but also a bit risky for the recipients. When it came out, PIP went bankrupt immediately, so one needed to find a new defendant. And what was targeted, it was the certification organization, TÜV Rheinland, which had certified the safety of the products, which is one essential ingredient of the EU medical safety devices law. The producer is only allowed to put safe medical devices on the market into circulation. And in the case of high-risk products, such as breast implants, he is only allowed to do that after he has obtained certification from one of those certification organizations called notified bodies. Those notified bodies, again, as in the TÜV case, they are accredited by the state, they are chosen, or they have to fulfill strict requirement as to their independence, expertise, etc. So it's pretty much the same type of structure. The only difference being that, let's skip that for a moment. The debates that we had, in particular in the German courts, was then what exactly was the role of the certification organization and who was to benefit from that role. And some German courts came to the conclusion that it was a purely internal role, and they were only meant to help the producer to put the products into circulation, which we always contested. The case then went up to the European Court of Justice, and one of the questions to be solved was the question, who was the beneficiary of that duty? And the European Court of Justice made it clear that the very role of the certification organization in the system is to protect the patients. So again, that sort of connection here. The one other part of it was, of the judgment was, but according to the Court of Justice, EU law as such does not require direct liability after certification organization under tort or whatever to those third parties, but that's a matter of national law. Okay. The other question, of course, that under German law, the solution was then pretty easy in principle, because under German law, if someone violates, breaches a law that is meant to protect the victim, that as such is a tort and lead to liability. So we have a rule on that. Just in the individual case, the court, our Supreme Court came to the conclusion that there had been no breach, which again is contested.
Okay, so we had a ruling, Supreme Court ruling saying, okay, in principle, if the certification organization breaches this statutory duty derived from European law, there would be liability. But nevertheless, there was an ongoing academic discussion on the role of liability with a view to certification organization. And again, the argument was, we have in the European Union, comparable to the national level, we have this responsibility to ensure protection, which not only translates to this pre-market control, but also to a liability ex post. And the central role which these certification organizations play with a view to ensuring safety towards third parties directly translates into a duty of care vis-a-vis the third parties. So in principle, there should also be liability from the tort of negligence in case the duty of care has been infringed. And the relevant difference would be that the organization would not only be liable just for infringements of the concrete duties derived from the statute, from European law, but to all damages which could have been foreseen and avoided. And that could be beyond the concrete duties in European law, but just to everything that has, could be regarded as foreseeable and avoidable.
Hey, I want to add a third possible route of liability, which is a very German thing. It's called a contract with protective effect on third parties. And I want to mention that because we need it for the next slides, for the more slippery ones. The contract with protective effect on third parties, as I said, is a very German thing, and it was meant originally, or it was developed because our tort law is somewhat deficient, and the courts tried to find a way around the problem. I guess we have 20 minutes each, do we? There are basically two case groups for that. One is kind of expert liability, which I can skip now, which is about trust in expertise. And the other one is where the third party is sort of the real benefit or an additional beneficiary to the of the contractual duty. The construction is somewhere between contract and tort, which we can see when we look at the fact that the question of whether a contract has this kind of protective effect is interpreted objectively by the courts. So it doesn't really matter that whether the parties to the contract wanted that protective effect, but whether it makes sense in the whole context, under good faith, etc., that it does have that protective effect. So, and that protective effect is in particular found where one of the parties has a responsibility for the third party that is outside the contract. It's responsible for the well-being of the third party. Get back to that in a moment. One limitation is that, again, sort of demarking that from tort law, that it should not cover an unforeseeable group of persons, but that group of potential beneficiaries must be somehow framed. Now we have the next step. Now we proceed to the transnational arena, where we only have voluntary certification systems, but no more mandatory ones, either based on public law, but mainly just related to public benefits, like in the biofuel thing, or public procurement, or things like that. Or what we do have as well is purely private voluntary certification systems. And now basically the same questions arise, apart from the fact we do no longer have any statutory duties, which could be infringed, but the question still is there with the contract with protective effects on third parties and just the tort of negligence. And here we still feel like confident that we can argue that from the very setup of the system, it is quite obvious that if you take this one, if you have a private standard organization such as the SA 8000 standard, which includes health and safety requirements, etc., and if you have certification organizations that have been accredited because of their expertise in that particular field, which have set up departments dealing with SA 8000, and who are then entrusted with controlling health and safety in that setting, that we find it difficult to argue that with an objective interpretation of that contract between the producer and the certification organization, that should not have that protective effect which is built into the system. So we would see here the idea that the whole system is meant to protect the employees, for example. Whether or not that comes out explicitly in that contract between the certification organization or not. I would even argue that it would be invalid if they had a disclaimer to the extent that they were not liable for what is the very purpose of their activity. So here we would see still a contract with protective effect on third parties simply from the whole setup of the system. Oh, it just reminded me of my promise to make a comparative remark. Under English law, we also have something that is sort of in between tort and contract, but it's on the tort side of things, which is tort of negligence in connection with assumption of responsibility. That is sort of a voluntary assumption of a responsibility that then leads to a duty of care in tort. And here, one case group is again expert liability, but it has also been applied, and it's even easier to apply for physical injury than to pure economic loss, where English law is, as German law, a bit tricky. And here we have physical injury, obviously. The assumption of liability, again, is a very flexible concept, and it has a lot to do with just, fair, and reasonable. And I think it is possible to argue that in this setting here, where, again, the certification organization has the very purpose, and the only purpose, to, at the end, protect the third parties, should be possible to argue that there is an assumption of responsibility to that effect, that a breach then leads to tort of negligence.
Okay. Now we have the situation where the certification is not enshrined in a system, but it is just up to the decision of the producer or of the parent company to, like in our original case, to employ a certifier like RENA or like the TÜV Rheinland in order to certify building safety or anything comparable. So here now we have the problem, we don't have a whole protective system where the certifier derives its duty of care from. So here it can only be transferred directly from the producer to the certification organization. So here in this example we have a clear duty of care of the parent company, which in that case would be derived from the new French Act on the responsibility of parent companies, which then translates into a duty of care. So just to level down complexity. So here we have a duty of care which could then be transferred to the certification organization. So this is, in principle, this is possible, but of course it depends on the concrete certification contract, whether a duty of care has been transferred, and it could only be transferred in that case. A certain part of the duty of care can be transferred because it can only be the identification of risks, not the initiation of remediation of risks. That, of course, remains with the parent company or with the buyer company, but at least the identification of risks could in principle be transferred, and then we would have a joint and several liability between the parent company or the buyer and the certification organization. And now this is basically our original starting point. Yeah, we even have the question whether the parent or the buyer owes a duty of care to the injured workers or neighbors in the vicinity. And here, we are at the moment, of course, in the area of the famous Chandler criteria, when that in principle you could argue that at least the parent can owe a duty of care in case he is in the same business, has superior risk knowledge, knows that the workplace is unsafe, and that the employees rely on him using its superior knowledge to protect him. This has just recently, 2 weeks ago or something like that, been even extended by the ruling of the Court of Appeal in the Vedanta case. It was just a ruling on jurisdiction where they checked whether the case has a chance to succeed on the merits of the case, but nevertheless, what was argued in that case was it is not necessary that the parent has to have superior knowledge. It would suffice that they have equal knowledge and they share responsibility. And they also highlighted not only the fact that it really actually controls health and safety, but that there is a certain intent to do that, so which could also be derived from codes of conduct or respective self-commitments. And another thing, so this would be relevant for the question of whether this could also be these arguments could be used for the responsibility of buyers. Of course, that was the case of a parent, but the corporate structure was not relevant in the ruling, and so the question arises in the actual case, whether that could be transferred to buyers. And here you could argue, building safety and things like that, you do not necessarily have superior knowledge with the buyer in these very basic things, apart from a transfer of risk technology, of treatment of wastewater or things like that, which we have in the environmental cases. But in these cases, equal knowledge would be sufficient. Yeah, and another extension was that it could also apply to neighbors affected by pollution, neighbors who live in the vicinity, and not only to workers. So we have in principle, it would be possible.
So if we assume, just one word again on the contract thing, but if we assume that in certain situations there can be a duty here, that duty can then also be transferred or partly transferred to the certification organization, and the same would be relevant in that contract with protective effect on third parties, because, as I mentioned earlier, that protective effect will be easier be found where the one contracting party has a responsibility for that third party, which here in that sort of duty of care context would arise, which then would also probably influence the interpretation of that certification contract. So that's the end point of our slope, and we're open to critique. Thank you.